call at this time. November 16th. Bob, continue. Thank you.
Thank you.
Court calls the case. People versus Kenneth Green Austin.
They didn't care. It's
Good afternoon, Your Honor.
need to see that somebody.
Good morning, Your Honor. Marcia Crater on behalf of,
If
and
he
I'm trying
needs
to
to be in a
shut this
facility.
thing. There we go.
Why
Good
do I have
afternoon.
like 8 different people talking to me? Go ahead.
I'm sorry. Good morning.
Okay.
Marcia Crater on behalf of the defendant. Your Honor, we'd be respectfully asking for this to be set for preliminary exam.
The prosecutor put on there.
No, he just turned on his camera.
Okay. Ms. Crater, let's try to do this in the order we normally do it. I'll call the case again. People state your appearance, please.
Nimish Ganatra, First Assistant Prosecuting Attorney for the People.
All right. Ms. Crater, you have put on your appearance. What are we,
Yeah.
and Mr. Green Austin, can you state your name, please?
Kenneth Green Austin.
Thank you, sir. All right. Now, Ms. Crater, what would you like to do?
I'm sorry, I got distracted. I apologize for not following the protocol. Your Honor, we would be requesting a preliminary exam.
See my arrow way on this. I don't see my arrow. Oh, I got it. And all discovery is taken care of?
Yes, Your Honor.
And the witnesses, as well as the people now, are available.
Yes, Your Honor, if we could have 2 weeks out, not next week, I'd appreciate that. He's being held on another matter.
All right, very good. November 7th, is that?
Yes, sir.
Preliminary examination will be set November 7th. Yeah, I set up November 7th, 2023, 9 a.m. And that is before Judge Barr in person. Bond will continue.
Thank you, Your Honor.
Thank you. Court does call the case of the People versus Trey McAllister.
Nicole Hughes on behalf of the people.
Bridget Coons on behalf of Mr. McAllister. Mr. McAllister, if you can, unmute yourself and state your name.
Hi there. My name is Trey Lamar McAllister.
Sir. All right, what are we doing?
Your Honor, we would ask for adjournment. Mr. McAllister was referred to mental health court. He has completed an intake. We're just waiting on the final determination for that.
And how? You want the 9th or the 16th?
Can we have the 9th date?
Probable cause conference, November 9th, 2023, 9 a.m. The Zoom invite indicates bond will continue. Thank you.
Your Honor, can we actually address bond as well on this file?
Quickly.
So Mr. McAllister currently has housing through Avalon that he doesn't want to lose. He is able to retain a job as a landscaping contractor through Dave's Drywall in Ann Arbor, as well as working for Ground Cover News. He's been in jail for the last 30 days. We would be asking for a bond reduction to a personal bond.
Before I get a response, have you talked to the folks at Avalon Housing? Is he even in jeopardy of losing his housing?
I have not had the opportunity.
Yeah, okay. Response?
Your Honor, this motion was heard at the last probable cause conference and denied. The defendant is in custody for his failure to appear here at a PCC on September 21st. The court issued a bench warrant with a cash surety bond. At the time that he failed to appear, he also had a community corrections bond violation in the report. He was ordered to report to community corrections, and by the time he failed to appear, he had never reported to community corrections. At this point, we have nothing has changed on that. I have no reason to believe that he will be otherwise appearing or compliant. In addition to that, my office is reviewing another warrant request for him for larceny in a building as well. He does also have a retail fraud third case that he is in custody on. I will say his bond on that case, though, is $100, but it has not been posted.
For bond reductions denied again. Thank you.
Thank you.
Court calls the case, People versus Theophilus Smith.
Nicole Quill Hughes on behalf of the people.
Edward Drukas on behalf of Theopolis Smith.
Mr. Smith, can you state your name, please?
Theophilus Smith. May I go in the breakout room with my attorney, Your Honor?
No.
Because I haven't,
Pardon?
because I wanted to change some things I wanted to do. Me and him talked briefly, but I didn't get down to the A's and B's.
You didn't get down to what?
I wasn't able to tell my attorney exactly what I wanted him to do for me today.
Mr. Drukas,
Thank you, Your Honor. Actually, I did spend about 50 minutes with him here this morning. I did get the discovery. There are some video that I did start to go over with him. We also discussed some potential other video that may still be outstanding. And again, I was appointed yesterday. I'm looking to get an adjournment today, so I can fully go over the discovery with him and make a determination on what to do.
probable cause conference in this matter, November 9th,
Did you
2023,
address bond?
9 a.m. Excuse me?
Can my attorney address my bond?
Well, he knows how to do that, but yeah, go ahead, Mr. Drukas.
Mr. Smith, I had gone over that with you. With regard to right now, we're not going to be addressing bond.
I didn't want to, that's why I wanted to go into the breakout room so we could be on the same page.
I know.
Your
We
Honor,
don't need
for
to,
the
you don't need to
record-
go over this on the record, Mr. Smith.
Mr. Drukas, for the record, should defense counsel address bond, I will be asking the court to increase the defendant's bond. I understand why Mr. Drukas is making the decision he's making.
Okay, I understand. When is my next court day?
So are we done with the bond thing?
He ain't even address it.
Yes, Your Honor. I believe you had said November 9th.
Mr. Durkin,
Yes, Your Honor.
do you want to address bond? He wants to address bond.
No, Your Honor. I'm asking for that
Is,
XBC on November 9th.
Mr. Smith, the risk is if I address bond, I'm going to address all bond. I'm going to leave it where it is right now, but the people have made it clear that they're going to be asking for an increase. Your counsel is making a strategic decision not to address bond at this time. But if you wish bond be addressed, then
No, I did not want to postpone my preliminary. I wanted my preliminary to be, I didn't want to post no more probable cause. I want to move towards the preliminary. I don't want to have another probable cause conference.
have you looked
That's why
over
me and my
all
attorney not even on the
Mr.
same page. Me and my attorney.
Mr. Smith,
don't do
Mr.
this.
Smith, did you listen to what your attorney said? There's video he still has to go through with you.
Yeah, but
So you want to have your preliminary examination before that happens? Because if I said it, I'm going to instruct the judge that not to adjourn it because you want to look at the video now.
To be clear for the record, the videos that we have turned over to defense counsel include the defendant brutally assaulting a victim. She was on the ground. He kicked her in the face repeatedly until she was left with what looked like a broken jaw to the police. She could not open her mouth and she could not speak, and she was rushed to the hospital. Defense counsel has requested an adjournment and requested that I look into whether there are additional videos leading up to the assault to help Mr. Smith explain to the court perhaps what happened leading up to that. I am more than happy to continue to a preliminary exam with the only evidence available being the brutal assault that this man committed on that woman. So, Your Honor, if we want to go to an exam, let's go, but I will not be getting those videos turned over before that exam date.
Hey, what do you folks want to do?
Breakout room with my attorney, Your Honor.
No, I already said no.
So
you wanted that, you already spoke to your attorney. Your attorney had a very clear picture as to what he wanted to do. You come here this morning, I think changing things. And I just want, if you want it set for an exam, I'll give you an exam. I'm assuming that setting it for an exam, Mr. Drukas, that would be over your advice to him at this point.
That is correct, Your Honor. Mr. Smith, let's proceed to November 9th and we'll continue to negotiate with the prosecutor.
No, I want to say it to the exam.
Okay, well, that's against my advice, Your Honor. We can have an exam.
Ms. Hughes, ready to go to exam this Tuesday?
We will do everything we can to get the victim there, and hopefully,
All right.
given her injury, she's able to speak at that point.
All right. Well, we'll figure it out at that
Now, can
point.
we address bond?
We'll start his exam.
Can we address?
We'll start his
bond?
exam October 31st,
Can we address? bond?
2023, 9 a.m. That's before me. Oh, joy. All right. Mr. Drukas, I
Yes, Your
realize
Honor.
your client's pushing you over your advice. Do you want me to address bond?
No, Your Honor.
Mr. Smith, you want me to address bond
Please, Your Honor.
over your attorney's advice?
Yes.
Okay, go ahead. Tell me what you want me to know.
Your Honor, my name is Theophilus Smith. I'm paranoid schizophrenic type 1, 2, and 3, and bipolar type 1 and 2. I had a rough breaking up, Your Honor. I knew I should have called the law. I should have called the police when he was making all them.
I'm going to stop you right there, Mr. Smith. I don't want to go into the facts of this case.
No, just let me talk, Drukas. Please let me talk. It's between me and the judge.
Well, you can't talk about the facts of the case.
Your Honor.
Mr. Smith,
Yes.
just because you're going over the advice of counsel, I'm just going to advise you that anything you say can be used against you. You understand that?
Yes, Your Honor.
Okay. I've given you your warning and admonition. Go ahead.
Okay, Your Honor. Well, pertaining to the case,
And I'm going to stop you right there again, Mr. Smith. I'd prefer that you not speak about this case.
but I'm asking you to address bond and you're not doing nothing I want you to do. So let me do what I have to do for myself. This for me, not for you.
I know. And we talked about this. This is about
I know,
you.
but guess what? You not listening to nothing I'm saying. I would rather have Lamus represent me. Lamus. Because you're not doing nothing I said. And me and you did, we weren't even on the same page. We weren't even on the same page before the meeting ended earlier. So just let me talk without you objecting to your own client. Can you let me
All
speak?
right. Mr. Smith, you seem to know better. You go ahead.
Your Honor, the defendant made several death threats to me. Not the defendant, the accuser. I don't know how the accuser knocked on my apartment door.
And again, Mr. Smith, I'm going to reiterate that you should not be speaking about the facts of this case.
Okay, I'm not going to speak about the facts of the
Okay,
case.
thank
Your
you.
Honor, Your Honor, if you could please give me a personal reconduct bond. Your Honor, I'm not a flight risk. I'm going to be in court on Tuesday. If you can lower my bond or give me a PR, Your Honor, I won't speak about no more of the facts of the case until Tuesday. I'm going to respect Edward Drukas on that point that I won't speak on the case. But if you could just give me a PR bond or lower my bond, because my family is not wealthy, Your Honor. We are not wealthy, and I can't afford $50,000, no 10%. Your Honor, if you can please just give me a chance to give me a real lawyer. Give me a lawyer.
Real lawyer?
No, a lawyer. No, I don't mean. I'm not taking nothing away from Drukas. I'm not taking nothing away from Drukas, Your Honor. I just want to check.
Oh, okay.
I just want to be free, Your Honor, because I feel like I'm not even guilty of this. My grandfather got inside of me. My grandfather was talking to me. My grandfather.
Ms. Hughes, response to the motion to reduce bond.
Thank you, Your Honor.
And Mr. Smith, before you go, Ms. Hughes, Mr. Smith,
Yes,
I
Your Honor.
warned you. I warned you. I told your counsel that if you ask me to address bond, I'm going to address the whole thing. So maybe when Ms. Hughes gets done, I haven't made a decision yet, but maybe when Ms. Hughes gets done, this bond goes up. I gave you that warning and you went ahead. So now I'm going to let the people give their version. Go ahead, Ms. Hughes.
Thank you, Your Honor. The people are requesting that this court set bond in the amount of $250 cash only. Notably here, the defendant's bond is $50,000 cash only. This is not even a cash surety case, never mind a 10%, which I think is pretty telling given how unique that type of bond is. The defendant is on misdemeanor probation for use of cocaine. It was initially charged as possession of cocaine, and it was pled down to use. At the time of his arraignment in this case, he was already in violation status of his misdemeanor probation. The defendant has a criminal history dating back, as far as I can see, to 2000, which includes a number of drug and alcohol misdemeanor offenses. He also has 6 assaultive felony convictions. In 2014, he was convicted of a couple of cases of R&O on the police. In 2019, he was convicted of felonious assault and CCW. In this case, this occurred in Miller Manor inside the apartment building, and the apartment building has cameras in the hallway. This case came to the police attention because a neighbor in Miller Manor heard yelling in a hallway. He exited his apartment, went into the hallway, and saw the defendant standing over a woman who had been brutally beat. She was laying on the apartment hallway floor, unable to get away from the defendant. The defendant then fled, went into his apartment. When the police arrived, they first tried to make contact with the defendant. He refused to open the door, refused to provide his name, refused to cooperate with the police. When the police made contact with the victim, her face was so damaged that she could not speak. She could not open her mouth. The police tried to interview her, and she could not even remain conscious. They were able to get her to agree to a medical release, and by the time they presented the medical release to her, she was no longer conscious to be able to sign it. The report indicates that she had injuries to her nose, to her cheeks, and to her jaw. She was immediately rushed to U of M. I am still waiting on her medical records to determine the extent of her injuries, but based on the police report, the police believe that her jaw was in fact broken, which is why her face was swollen and she was unable to speak. Again, Your Honor, our request is $250 cash only.
Anything else from the defense?
I think enough has been said, Your Honor. Nothing further.
Court believes, and the court would find that the setting of, under the circumstances of this case, that, and with all due respect to the magistrate, I understand what they were going through at the time, that the bond that is set at that time, court would find that under the circumstances of this case, that may have been an abuse of discretion. The court will increase the defendant's bond in this matter, finding that the defendant is a risk to the public. A clear danger to the public given the circumstances of what the court has heard. Defendant's bond is increased in the amount of $2,000 or $200,000 cash surety. Thank you.
I'll come and see you, Mr. Smith.
Thank you, Your Honor.
Court calls the case, People versus Raheem Bragg.
Marie Rasinski on behalf of the people.
Ready again, Judge. Torshell Feaster, Assistant Public Defender on behalf of Mr. Raheem Bragg. Mr. Bragg, please state your name for the record.
Raheem Bragg.
Thank you, Judge. I've spoken to Mr. Bragg as well as some of my colleagues have also spoken to Mr. Bragg. I know Mr. Bragg had previously been before Your Honor asking about a video. I will put on the record that I've spoken to Mr. Ganatra. We have via email, and we understand that video is no longer available, does not exist. Based on those facts, I think Mr. Bragg does want this matter set for the soonest possible preliminary examination, Your Honor.
preliminary examination in person will be set November 7th, 2023, 9 a.m. I should have asked. All discovery then, as you're aware, is complete.
That's my understanding, Judge, yes.
Could I get
All
bond
right.
as well?
And the people, you will have your witnesses by the 7th.
Yes, Your Honor.
All right.
It sounds like Mr. Bragg is asking that I request bond, Your Honor.
Yeah. Okay. It's going to be that kind of day. Go ahead.
Thank you, Judge. I have met with Mr. Bragg. He does have a couple other cases that are pending. I think Mr. Bragg told me that he has received bonds on those matters. So I think this is the only thing that's holding him. I think he's asking the court to consider a personal bond or a reduction, Your Honor.
So he's been released on everything else?
Is that correct, Mr. Bragg?
Yes.
I know he has a
Okay.
circuit. I know he has a circuit court case, Judge.
Yes,
I'm not sure what the bond is.
Carlos was the only other case I had, and I've been released on the PR bond, and it was just like community corrections or something. It wasn't like, I don't know, but I have been released on it.
Response from the people.
Your Honor, we believe that bond is set appropriately. This is a felon in possession of ammo case, and he also has another open felon in possession of a firearm and fleeing police case. This was previously set for a preliminary exam, and the defendant failed to appear.
I know that was before me, I think. Go ahead.
And he's also failed to appear for a previous probable cause conference in August on the 17th. We believe that the defendant is a flight risk and bond should be kept the same.
Just so you know, Judge, I am looking at our notes in our system. It does look like he was arraigned by Judge Conlon on that circuit court matter, and it looks like he was granted a personal bond on that file, Judge. So this does appear to be the only thing.
And the problem is he didn't show up for a preliminary examination before me.
That's
and
correct.
so this actually has to go back before me. So I can't set it. Would the people be ready to go on the 31st? Because
I believe so, Your Honor.
all right, then I'm going to set his preliminary examination since it's my case. October 31st, 2023, 9 a.m. before me. Motion for bond reduction is denied. Bond will continue. Thank you.
Thank you, Your Honor.
Thank you, Judge.
Great. Court calls the case People versus James Paul Austin.
We are quietly ready.
You guys have a hearing with this Hudson tomorrow?
Good morning, Your Honor. Amy Reiser on behalf of the people.
And Lauren Brown, Deputy Chief Public Defender, appearing with and on behalf of Mr. James Austin. Mr. Austin, please state your name for the record.
It's James Austin.
All right. What are we doing?
Your Honor, today is the date and time set for the probable cause conference. My client already has a preliminary examination set for November 27th for a different matter. We'd ask if this could be linked up with that. And, Your Honor, I'd like to note for the record, at the appropriate time, we will not be addressing bond.
All right. You have one. He already has one set November 27th.
Yes, that's my understanding. Is that correct, Ms. Reiser?
Partially correct. We just were notified from Judge Valvo's court this week that it needed to be moved from November 27th. We were before Judge Valvo last week, and then we adjourned to allow this case to be heard at the same time. She gave us a special date, but she emailed Mr. Banis and I that she wasn't available on the 27th.